So, in regards to like our constitution,
Hmm.
um, we had David Koizi's Professor David Koizi's on. He wrote the book Political Illusions, and
Political
and he
visions and illusions. It's a really
yeah,
good book.
political
Yeah,
visions,
yeah.
political visions and illusions. And and he made a point about how there are some deficiencies in our constitution, in the sense it's not like the American
Hmm.
constitution. So because of some of the deficiencies that our constitution has, it kind of creates a window for problems to
Hmm.
happen like this.
Hmm. Yeah,
Um, what
that
would you say the differences between the two?
yeah. I mean, I wish I had studied more of American constitutionalism, but I think that the big difference that I'm aware of is that what Canada has in our charter is Section 1, which they don't have an equivalent of in the American Bill of Rights. And what our Section 1 does is it says that all of the freedoms and all of the rights that follow in the charter, so your fundamental freedoms of religion and conscience and expression and association and so on, and your legal rights, they're all subject to what's called a reasonable limits clause in Section 1. Section 1 talks about how all of the rights and freedoms guaranteed in the charter are subject to such reasonable limits as are prescribed by law, as can be demonstrably justified in a free and democratic society. So it's called the limitation. Well, it's actually in the charter. It's called the guarantee clause because it's supposed to be about guaranteeing our rights and freedoms, but it's
Hmm,
become our limitation clause, limitations on rights. And
hmm,
so what happens is that our judges, if you make a claim in court that says the government has violated my freedom of religion or the government has violated my freedom of expression, then that's not the end of the analysis. You have to prove in court that they have violated your freedom, but then the government gets to prove, they have an opportunity to prove, it's like, yeah, but it was reasonable. It was reasonable and necessary in a free and democratic society to limit that person's right because of X, Y, Z. And then the judge actually does the balancing exercise. And so I think that it's understandable that we wouldn't say freedom of religion should be an absolute right in the sense that anyone who says, oh, I need to do this or that practice because it's my religion, and so the government can't do anything about it. Think about, for example, female genital mutilation, which has been defended as a religious practice, or there used to be a Hindu practice of burning a widow alive on the funeral pyre of her dead husband. No one in Canada would say that, oh, that should be a religious practice protected by freedom of religion. Of course not. There has to be a reasonable limit in a free and democratic society that says, well, no, we don't do that. We don't
hmm.
do that religious practice here. It's not okay, and we will prohibit it by law, as we should. But what has happened instead is that actually there's a whole lot more of our religious practices and beliefs that have been limited more and more and more by the massive growth of what's called the administrative state, that is the bureaucracy. And that as the bureaucracy grows, the more it interferes with religious practices, whether that's in education or in worship or in social services, including things like counseling, what we're talking about now. And as the state grows, judges have become, I think the trend has been that they've become more and more deferential to the state bureaucracy. And there's this level of trust that the judiciary, the judges have, not of the citizens, but of the bureaucracy, to say, well, the bureaucracy, they have these experts in medicine and they have these experts in law and they have experts in counseling or experts in all kinds of other things. And so those experts say that we need to restrict this or that religious practice. And so they keep deferring to the reasonableness claims of the bureaucracy. And that's a big impediment. They're not, it seems to me that the trend has been, especially as it relates to the fundamental freedoms, the trend has been that our courts are much too deferential to the administrative state, to the bureaucracy.
Please subscribe and hit the bell to stay up to date. If you liked or disliked the snippet, give it a like and share your 2 cents with us in the comment section. And remember, 6 cents makes change.